to the Retired Living True series, and today's topic, planning for life's later stages. And we're really going to talk about estate planning. Who already has an estate plan in place? And keep your hand up if you have 100% confidence that you have everything covered. A few people, that's good. I'm glad there's some people here that are confident. So, Annette and I often have clients coming to us. We have a real estate business, and we often have clients coming to us, and there are definitely some myths or misunderstandings in terms of how these estate plans and wills and probate and so forth work. And quite a number of our education partners kind of experience the same thing, whether it's moving into a community or whether it's one of the other service providers. There's definitely some misunderstandings. So what we thought we would do today is go through some common myths collectively all of our education partners encounter with the help of our trust company and our law company. So they're going to join us up on stage shortly. And in your handout, you will find we've listed down the myths and a corresponding truth. So that was trying to help you take less notes. What you'll find is that the truth is very short. We can only write so much. But our speakers will have a lot more information and the nuances behind what each of those mean. Hopefully you can take some notes alongside what we have there as a starting point.
And then also, before we get started, I just wanted to, we don't have a slide for this. If you could get out your pens and write on your paper, save the date. We have done pictures in the park, portraits in the park for the past 3 years. And it's our way of giving back. So if you would like a photo with a professional photo taken with your family, your pet, your best friends, whomever it is that's important to you, on September 14th, which is a Sunday, we are doing portraits in the park from 10 a.m. to 1 p.m. and you'll end up signing up for time slots. We will be sending out a mailer on this and another announcement, but just letting you know that save the date, September 14th. It's a Sunday from 10 to 1. And we are going to be serving food there as well, so we welcome you to come.
I think we're calling it portraits in the park and pastries or something to that
Portraits and pastries.
Yeah.
So we'll have more than pastries, but.
So love to have you come and join us.
Yes.
One other announcement, we're always looking for people to help as ambassadors. So we have some wonderful ambassadors that help greet you as you're coming in, help at the door and so forth. But if you have an interest in helping us, helping our audience each month, we'd love to have more ambassadors. And if you are interested and would like to learn more about being an ambassador, on your yellow evaluation form, you'll find there's a checkbox there that you can mark if you would like us to reach out and tell you a little bit more about what being an ambassador is. Anything else?
I think we're good.
Yeah. So with that, I'd like to have Rich and Lou come up and join me on stage. So maybe if I could start with you, Rich, could you introduce who you are and why you might be here with us today for those who don't already know you?
Sure. My name is Rich Schultz. I'm an estate planning and elder law attorney. I've been doing that for 30 years, which is a lot longer than I thought I would ever be doing anything except breathing. And the way I use the words estate planning and elder law, because they really don't mean anything. If you look it up on the internet, there's 10,000 definitions. Estate planning is planning for and managing everything that happens when you stop breathing. So wills, trusts, probate, estate taxes, those kind of things. Elder law, the way I use it, is what happens when you don't die on time. My client came up with that, not with me, but it's end-of-life decision-making, it's guardianships, it's powers of attorney, it's veterans benefits, Medicaid, those kind of things. Yeah.
Thank you, Rich. Lou.
Lou Robinson, President and CEO of Alliance Trust Company. We are a corporate trustee in Nevada, which is now the number one jurisdiction in the world to have your trust set up. And we administer trusts for families, not just in cases where somebody's passed away, but people who have trusts that have a specific purpose, special needs, maybe a tax play. we do all that type of work. But by far and away, my favorite work is the successor trustee, the winding up of affairs after somebody's gone. I find that work to be the most interesting, and we get, I think, a great sense of who the people were when they were alive when we get to do that. And I really feel like we're super lucky to get that window into other people's lives. So I'm here today to talk about that portion of our business and how we work with people like Rich when you don't die on time.
Thank you, Lou. Who knows when they're going to die? Does anyone have that kind of locked in? Helps with planning if we know exactly when. Yeah, a little bit hard to predict, isn't it? We just need to prepare the best that we can. So on your handout, you have this single-page handout. On the back of it are the myths and truths that we're going to go through. And my job's really easy today because I'm basically going to just read out the myths, which you could probably just do yourself. But I'll have some good follow-up questions, I think, for both Rich and Lou. So let's start with the first one. Our first myth, a designated, and this is for you, Rich, a designated person can handle my affairs by simply using a completed and notarized durable power of attorney or specific power of attorney form found online. So the one here we commonly get is, I can just go online, print out a form, fill it in, and I'm good to go. I don't need to go see an attorney. It's just going to be really easy. So help us understand that better, why that might not be the optimal way to go. What are some of the catches with that?
You know, I get that all the time, right? Nobody wants to hire a lawyer because we're too expensive and all of that. And there are a lot of very good online resources. I don't know if you've looked out there. The real challenge is, and there's 2 of them or 3 of them or 20 of them.
Rich, can you just hold your mic a little closer?
Yep. So there's a lot of challenges, and I think the biggest challenge is that the form you download may not be statutorily compliant. So Nevada, most states have laws that say if you have a power of attorney, it's got to say this on it and that on it. It's got to be executed properly, etc. And I've had clients come in where they've downloaded it from one of the sites where you pay like $50 and they download the form, and it's nowhere near appropriate. You know, it's 3 pages long. It doesn't have the right disclosures on it, and the difficulty with that is and then the other one that you get with the myth that comes up that's a problem is there's options on the power of attorney, you know, and it's like, well, which option do I choose? And if you choose the wrong option, it can be worse than having no power of attorney at all, right? A power of attorney is there so that when things go bad, somebody can act in your place. And if you need a power of attorney, it means things went really bad. And if you have a form that you've downloaded off the internet that's not completed correctly or not executed correctly or simply doesn't comply with the law, now it is literally worse than having nothing.
So where would that come back to bite me? I go to hand that over to whom would be some examples?
Sure. So let's say you have to go, you lose your mind, can't take care of yourself, and we need to access your IRA to pay your bills. And the person you designated takes that power of attorney you downloaded off the internet to Wells Fargo, because I like picking on Wells Fargo, or Bank of America. But the corporate legal department looks at it and says that's not valid. That is a one-way ticket to guardianship court. And a guardianship is, my mentor described it this way, and I love it, but I thought he was overreacting, and he's not. It's a lawsuit you start with yourself, paid for with your own money, that ends when you die, and then you get to go through probate. But basically, it's handing your life, everything about you, over to the court. All decision-making, where you live, who your doctors are, what medicines you take, who gets to visit you, who doesn't get to visit you. All of that is now under court control. So a lot of times we do powers of attorney to avoid that from happening. So it's worth a little bit of an investment to make sure that doesn't happen.
And I would just say from my own, from our experience as a trust company, because sometimes we do step in before people pass away when they're incapacitated, is that those power of attorney documents, the compliance departments for every major financial institution has become so risk averse over the last few years that it literally can take 12 to 18 months to get control over an account if everything's not filled out properly. And even signed orders from judges, I've had one financial institution in particular say that they don't care. Their compliance department said no. I finally got somebody that hadn't lost their mind in their compliance department when I said, look, if you're telling the judge no, that's fine. I will go let him know, and we'll see what the next order he issues is. But I mean, it's really problematic. So if there's anything out of place with your power of attorney, the banks, the large financial institutions will just sit on it because they're so afraid of being sued or making a wrong decision.
Yeah, I think to add to that just real quickly is that when you need a power of attorney, it really does mean something went wrong and your life is not in good shape. And the last thing you want are those kind of questions. I think the other mistake that people make with powers of attorney frequently is that they work after I'm dead. A power of attorney is nominating someone to act in your place, but how can they act in your place if you're not breathing because you can't act? So power of attorney, I mean, that's probably one of the biggest myths we have. You know, I get 2-3 calls a week but I have mom's power of attorney. It doesn't matter that she's dead. Well, it ends when you die. So that's the other important point to make.
We get that all the time, yeah. Sale of the home, here's mum's power of attorney so we can sell the home. Well, no, it doesn't quite work that way.
Right.
Anything else on that, or move on to the next one?
Well, I think, I don't even know, I don't want to be dramatic about it, but the one document, if you're only going to do one thing, a general durable power of attorney is the single best investment you can make in maintaining control of your life, keeping the state out of your life, keeping the court out of your life, when and if something goes wrong and you need somebody to help you out. I don't mind you taking a shortcut on it because 9 times out of 10 I'm going to get guardianship out of it, and I make more out of a guardianship than I do doing a power of attorney. But you won't like it, and your family won't like it. So I know it's super tempting to use the online services. I mean, when I started, I always tell people, Quicken Family Lawyer was the first online service that came out. And Quicken, I worked for them actually for a little bit. I knew what they were trying to do. And they're a good company. If you use their QuickBooks and all that stuff, they're very good. And I thought, that's it, estate planning's dead, we're done. Maybe I lost a couple of estate plans, but what I picked up on the mess that people created by trying to do it on their own more than offset it. So I don't need to be cynical, but it's a relevant fact.
And with an accounting background, I will tell you that no non-accountants know how to use QuickBooks, as I found out over the years. But and I would just say, like, the power of attorney, Nevada's had a couple of black eye guardianship cases in the state. So now guardianship court in Nevada is very impossible. It's very restrictive because there was a couple of bad apples. So you definitely don't want to end up in the guardianship court because everything just grinds to a halt. But the other thing is, I just want to mention, is that with people living longer and Alzheimer's and dementia becoming more of a prevalent issue, we have been involved in several cases where that occurs and there's no power of attorney, and there's a very concerted effort now by international criminals to target the elderly. And they use, and I wasn't even aware of this till a couple of years ago, really, just kind of peripherally, but they all use the same playbook. And in the last 2 years, I've seen it probably 10 times where they do the exact same thing to elderly. They figure out a way to isolate them. They send limousine service to their house. They send them a new cell phone, tell them that somebody's listening in on their cell phone calls. And so they get them to use this new cell phone with none of their contacts in it, and they then are completely isolating this person from other people, and then they start draining the bank accounts. They convince them to go and transfer funds to a different account that they're a co-signer on. And I will tell you that those wire transfers, the second they leave the bank, you'll never see them again. There's no reversing them. There's no getting them back. And we just had a really tragic case where that happened with a woman. They got about $1 million before the court had to step in an emergency proceeding because there was no valid power of attorney.
Wow.
And during that period of time, those thieves were still getting funds, and there's just nothing that could stop it. An emergency order is still going to take, 10 to 14 days.
Thank you for sharing that, Lou. So I have two follow-up questions, Rich. Number one, what's the typical cost just for a power of attorney? Just industry, if we went to a local attorney somewhere, what might we be looking at just roughly?
I think cost-wise for power of attorney, for a good one is going to be maybe $200 to $300 because it's an hour of consult, right? A lawyer is not going to hand you a piece of paper and say, see ya, right? It's a very, very powerful document. So you really should have somebody sit down and walk you through it. So what I tell people, plan on spending an hour or two with the lawyer or, to really understand why am I initialing this and not that? What authority am I giving? When does it become effective? Those kind of things.
And I just wanted to say that, Rich, you generally include that in your overall estate planning package. That's just one of many documents, so you don't have to do them piecemeal.
Yeah, absolutely. I mean, yeah, sorry.
So, no, that's a great answer. And I'm going to kind of ask you as we go along, well, what would a will be? What would a trust be? And as you said, hopefully you're doing it all. But if people were only going to do one thing, for whatever reason, and as you mentioned, we should have a power of attorney. Yeah. Is there anyone in the room who shouldn't have a power of attorney? Is there any adult child that shouldn't? Or should we all, if we don't already, go out and get one?
I think everybody should. Because, well, actually, how many of you are married, right? How many of you think that your spouse can manage your affairs for you? Yeah, they can't. Call the utility company, right? I have charter, I tell this story. So we had a charter subscription. My wife and I got married. We lived separately for a while. Finally decided we're married. We should live together. Bought a house together. And we moved my charter account to our new house. And charter said, great, it's a new account, $89 a month. It was awesome, right? You get NFL package, NBA package, you get everything. 12 months later, it goes to $389. I was surprised. I shouldn't have been. And I waited on hold for a couple hours, and I don't like that. So Piper, my wife, says, I've got this, get away from the phone. So she calls back, gets through to somebody and says, hey, we got to talk to you about our bill. Okay, what's your name? Piper. Oh, no, the account's in Rich's name. And she couldn't talk to him. We had to do a power of attorney to allow her to talk to charter. So yeah, even if you're married, it's a very important document.
Thank you. So let's jump to the next myth. If I have a will, my estate will not have to go through probate. Another one we hear all the time. All I need is a will. And Lou, do you want to take it?
Yeah, so that's probably the biggest myth. The thing about a will is it guarantees that you're going to be in probate. That's your one-way ticket to probate court, actually, is a will. Just by its very nature, it is overseen by the probate court, which is, generally not where you want to end up. Everything's public. Every Wednesday, the commissioner does, what I call a cattle call, which is all the cases on the docket for that day. Everybody's listening in to all aspects of that case. Commissioner Gorman is actually a very qualified commissioner, does a great job, I think. But, I think even he would say he would rather you not end up in front of him, just because it creates a lot of difficulty. So, my opinion, a trust is generally the way to go. It gives you privacy, keeps you out of the probate court, allows who you designate to handle your affairs, generally without interference. Much easier process, and I think less expensive.
Is there any situations where a will is sufficient?
A will is better than nothing. And what I always tell people, if you know there's going to be a fight, the kids will fight, there's nobody you trust around, you haven't hired a Alliance Trust Company to manage things after your death, A will is not a bad thing, because it's like, with the difference between a street fight and a boxing match, the referee's in the ring when you start. Same thing with probate. If you know there's going to be a fight, the judge is in the fight when it starts. You can keep things under control. The other time I think it's sufficient is if you have a modest estate and you really just want to make sure things end up in the right place. So it is better than nothing.
Okay. And a cost of a will?
So I don't do standalone wills. I always do wills and healthcare directive and power of attorney together, because, I morally I just can't do that. Right around $1,200 usually.
Just for will. Thank you, Rich. So, next myth: estate planning is only for people who are retiring, retired, or very wealthy.
No. So, estate planning is telling people what you want done if you stop breathing. Well, not if, when you stop breathing. And at any point, any of us can stop breathing, right? I have, unfortunately, a friend who was very young, pass away. He was 31, almost 32. I have a client who thought he was going to die at 73 that just turned 97. So you just don't know. But delaying estate planning, even if you just have a will when you're young, to name somebody who's going to take care of your kids if you can't do it, or to keep your kids from receiving an inheritance at 18 when they shouldn't. But the biggest fights, I think Will can, or Lou can agree with this, is it's not the big estates where people fight. It's the small estates. If you think about it, if I have 3 kids and they're inheriting $600,000, that's the value of my home. They're each going to get $200,000. That's the most money they're ever going to see in their lives at one time. If you haven't done estate planning to direct where that's going to go, they will fight.
And I will just say, it's probably the most money they're ever going to spend all at once in their lives too, because when they're 18, they make really awful decisions.
Yeah. The worst case I had is a granddaughter inherited roughly $1 million from her grandmother. Her grandmother's a dealer at what is now the GSR, but was the Hilton. And she was at UNR, the granddaughter, received $1 million, came in and talked to me. We probated the house, got that done. She had about a $300,000 house, $700,000 in an IRA. 3 years, she comes back to me and says, I got this letter from the IRS. She spent the entire IRA in less than 3 years, never had taxes withheld. That was not a happy moment.
And I would just say too, you do never know when it's going to happen, and we're involved actually in a handful of really tragic cases where the parents pass away, leaving a minor child, and what is going to happen with them, and making sure that the money is handled correctly and not by a relative who may not have the child's best interest at heart, because there's a lot of instances where it's a big sum of money for the person that's going to take care of the child, and they look at it and say, well, this is a burden, I should be paid for this. And next thing you know, the child turns 18 and there's no money left. I've seen that happen numerous times. And so you just never know. Or, people love to mountain bike in this area. Well, we've had 2 different clients who have killed themselves mountain biking at a very young age, and had to take over their estate. So they were certainly very fit, not expecting anything to happen, but it did. They flipped their bike.
And I think related to that, so we've talked about death, but incompetency in healthcare decision making as well. I mentioned if you're married, you should have a power of attorney just almost as a matter of course, assuming you trust your spouse. But the other part of it is, pandemics, right? We just came through COVID. Well, not just, it feels like it. But lots of young people ended up on ventilators for months, right? What would you want to have happen if that was you? What would your kids want to have happen? Nobody wants to think about that. But I promise you, they have very strong feelings about what they want to have happen. And so getting that spelled out can be really helpful. Because I have daughters. My daughter right now is driving to, is it Glacier National Park, North Montana, for a music festival. Dear God, I'm not a predictor of the future, so I never even want to think about this, but God forbid something happened. She's a nurse. She's told me what she wants to have happen, but I don't want to be making that decision cold. Right? So leaving those around can be really helpful.
And then follow on, just the cost then to put in place the trust, will, power of attorney, just not your fee, but just typically what's kind of the ballpark?
Yeah, so our fee for a trust package is about $3,950, $4,000 all in. I've seen it, a document production paralegal firm, about $2,500. I think we're still on the low end of most law firms. I know there's a big law firm that does a bunch of marketing. They charge close to $5,000, $6,000.
Okay, so $2,500 to $6,000, depending on the services and so forth. Do you have something you wanted to add, Lou?
No.
Okay. So, cost of not having a trust. So you were talking about, Lou, avoiding probate. So what's the big deal with probate?
So, yeah, it's very expensive not having a trust. You get pushed into probate. Rich is happy. It's a very expensive engagement for him. The children are going, if there's multiple children and you end up with a probate with no estate planning documents, guaranteed they will fight, guaranteed they will spend a lot of money on legal fees that are completely unnecessary. And I think for anybody who has children, that's the last thing that you would want. But just as a general rule of thumb, children, when the parents die, children remember what their brother or sister did to them when they were 8. And it comes back with interest. That debt is due, and they will get their multiple pounds of flesh over the tearing the head off the Barbie doll or whatever it was that they did. So it definitely comes back with a vengeance without estate planning. The one thing about estate planning is it will actually keep some guardrails on the behavior a little bit. And if you appoint somebody else, like us, it gives those children a person to hate and take out their frustrations on instead of each other. So it makes for a happier group.
Yeah, I mean, the hard cost of a probate, about somewhere between 3% and 4% of the gross estate. So if you have $1 million estate and you owe $600,000, the probate costs are based on the $1 million, not the $400,000 the family's receiving. It's very expensive.
Which say that one more time. If I had a $600,000 house and I owe half on it, still $300,000.
Well, you have $1 million estate or a $1 million house,
yep.
And you have a $600,000 mortgage. So the kids, when it's sold, are going to get $400,000. The legal fees, the court fees, all the costs are based on the $1 million, not the $400,000 the kids will be receiving, which is great for lawyers. I mean, if you talk to any lawyer in the state, they're going to tell you, probate's not that bad. It's very simple. Yeah. They just don't tell you they're going to make, 40 grand when your kids are getting 400,000. The other part of it that, so when I talk to the clients, those of you who met with me, right, all my clients are like, oh, that's so expensive. But in probate in Washoe County, it's going to take 14 months at least from the date it starts, not the date you die, from the date we're able to get in front of the judge the first time till things are gone. So that means your kids never get to move on. They're waiting for 14 months.
The longest I've ever seen is 6.5 years. And that was one I was actually the administrator of. It was not my fault. It was just really a crazy case, and in the middle of COVID, which created its own challenges. But yeah, Rich is right. 14 months, I think that's quick if you're going through the probate court. That's best case scenario.
So if I'm not wanting mum's house, I already have a house, what am I doing with it for these 14 plus months?
Paying the expenses.
Yeah. Paying the
Trying to make
mortgage.
sure that it's not getting broken into because it's empty. Trying to get insurance on it because insurance companies don't like to insure a vacant house. And they will, but it's very expensive.
Thank you. I just wanted the audience to hear that.
And a lot of times they won't insure a vacant house anymore. A lot of companies, as soon as they find out you're not living there because you stop breathing, they'll run that term of the policy out and no renewals. And it is very expensive to keep a house empty and pay for it. Now you can sell it through probate, but you remember that 4% number that I gave you? That would now go to say 5 or 6%, because those are called extraordinary fees. And everything, again, goes through the court, gets approved by the court. You got to jump through a lot of hoops. It's not, well, it's fun for lawyers. It's kind of exciting. But for everybody else, it's not.
So I got to keep paying that mortgage, the property tax, the HOA, all the other things you mentioned in terms of upkeep, insurance.
Yeah, and HOAs generally are unsympathetic that you're dead. They don't care.
Yeah.
It's actually pretty awful. I've given my peace of mind to more than one HOA. They will start issuing fines because your grass has a few brown spots. Like, yeah, they're gone. You know, we're trying to get it under control. But I mean, they are just complete jerks, to be quite honest. So,
Thank you both. So next myth, estate planning only deals with what will happen with my belongings and assets after my death. Lou.
Actually, I think this is better for Rich to.
That's partly true. Again, that's why, you know, I call it elder law and estate planning, elder care and estate planning. To a certain extent, estate planning does only deal with what happens after you die and where your things go. But it should also deal with how they get there, right? Who's in charge? How are things distributed? How quickly are they distributed? Does it make sense to give my daughter, who's, you know, had a good life but had a little trouble holding on to money, you know, $300,000, $100,000 in one lump sum? Maybe that needs to be stretched out. You know, does it make sense to give my grandkids, maybe they're my heirs, and I love my grandkids and I want to give them money to get started with school, so I just named them, and it turns out that at 18, if you don't put, you know, brackets around this, they'll get a check. Now at 18, I can tell you they're not interested in how to wisely spend whatever they get. Well, they might be wise for them, right? That new car, the lifted truck, that kind of stuff. But estate planning also needs to deal with, as we've said before, what happens to you if you're still breathing and your brain's not working? You know, I think estate planning, you know, the two biggest gifts you can give your kids, you know, I mentioned the power of attorney is the biggest one for you. The biggest gifts you'll give your kids are what you want done at the end of life. So end of life decision making, guidelines of what to happen as, you know, nature's closing the door for you. And then what to do with your body when you're done using it. Those are big, big fights. Even if it's the best family in the world, right? You know, everybody in here, I think all of our parents have died probably by now, except there's some young folks here. You know, when that happens, were you emotionally stable? I wasn't making good decisions. You know, my sister and I had my sister's the daughter that shouldn't be getting any money, but aside from that, you know, we ended up having a knockdown, drag-out fight. My brother got involved trying to mediate it, then kept switching sides. You know, and it was just nothing but, really, that was over what to do with my mom's body. We didn't even get to the house and the rest of it.
Yeah, and in my family, my brother and my sister and I all get along great. My sister's really an incredibly nice person, so is my brother. My sister wanted to take half my mom's ashes home with her back to Ohio, which is where we grew up, and that caused World War III. Just the concept of splitting my mom's ashes was really untenable for my brother, and I just couldn't believe how big a deal it was. And, you know, I mean, those are the types of things that, you know, I agree with Rich. The best gift you can give your children is kind of a roadmap for them to follow, especially the end-of-life care part. That's really, those are the hardest decisions by far. I know for me and my siblings, that was the hardest decision ever, having to do with my mom, and we had no guidance, no anything to go off of, and it was pretty difficult.
So that'd be a good one to cover. Ashes, I want them in one place,
Yes,
or I don't care, or...
And that creates a huge issue. I'm surprised at how often, now that I've been doing this for a lot of years, how often I hear that same story. It was an issue for my wife's family. It was an issue for my family. I hear it all the time. Where are the ashes? Who has the ashes? What are you doing with them? Everybody fights over them, and then they throw it in a garage and never see it again until they move. They go, oh, there's those ashes.
I have the opposite family. I had a family member die recently, and the surviving spouse allocated the ashes into separate little wooden boxes, whatever they're going to call those things, and distributed them all to the family. And so they got shipped to our house to distribute, and the family showed up, and everybody kind of looked at it and said, wait, what is this, and why do I want it? That happens too, right? So kind of the opposite situation where it's like, so we have, if you ever come to my house, we have these very beautiful boxes up on a shelf. I don't know what to do with them.
No one else wanted the boxes.
Nobody else. I don't want the boxes. I don't think anybody wants them. Sorry, that's just me. I don't want a body in my house. It's okay.
So I do have a follow-up question regarding assets that are in the trust and the directions for those. You and I talked a little bit about that, Lou. Should we be more specific if there are stocks, rental properties, whatever it might be, in terms of whether we just let the beneficiaries deal with it or we try to help provide some direction, whether it's for our spouse or for children? Just thoughts on that?
Yeah, and so on that, I've seen people do a lot of different things with their assets. One of the things we commonly see is real property, rental properties that the parents have. And generally speaking, I think most people, when they're thinking about distributions from a trust, they'll say, just give a third to each of my 3 children. So one of the things to be cognizant of there is, do your 3 children get along? Because I don't think anybody really kind of thinks this through, but if you're giving a third to each of them, you're not splitting up, one child's getting this property, another child's getting that property. It's going to end up each child owns a third of each property. So you just made your children business partners with each other, and I can tell you that is an absolute disaster. Rich has when we talk about kids, having to deal with the end stage of a parent's life, right? There's 3 kids, one who does everything, one who does nothing and disappears, and the other one who complains about what the other one's doing. And that's the same. Rental properties is just a recipe for disaster. I love my brother, think he's a great guy. He's a realtor as well. I would never in a million years own a property with him. We would kill each other. And so it's just, those types of things with assets inside a trust, people should, I think, really give a lot of thought into what you're doing there. Like, don't force your children to be business partners with each other, unless, that's a specific punishment you want to leave them with for something they did. But I just don't recommend it, because it's, no matter what happens, at some point, though, there's going to be a significant disagreement that could easily be avoided.
What about the family home between 2 or 3 siblings? Obviously, one is easy if there's only one, but if there's...
Yeah, that's an issue. And I'll just say, not to get too deep in the weeds on taxes, but one of the things that happens when you die is everything that you own is stepped up to fair market value. So that rental home that you've been depreciating for the last 30 years, that maybe has a value of, you know, 30,000 at this point, and you're not going to sell it while you're alive because you don't want to give the IRS your money, you know, when you die, that value gets reset to fair market value. And what that means is your heirs can sell everything the day after you're gone and not pay a penny in tax, unless you're, you know, over the estate tax threshold, which is going to 15 million. So anybody under 15 million, like, you can literally sell everything and just take the cash. And I will tell you that I see children agonize over, you know, they have an emotional attachment to your assets and will hang on to them even to their own detriment. And, you know, just they'll go broke trying to hang on to this stuff. Sometimes it's just better to just liquidate and give them cash, let them do whatever they want. And honestly, with real estate, I do think that that's a better way to go. Don't try and get, you know, well, this person maybe needs a place to stay more than this person. As soon as you start doing that, you are just laying the groundwork for resentment, which again, you know, some people, you know, I once asked a guy what he wanted to have happen when he died, and he said, I want everyone to fight. I said, okay, well, this plan is going to do that. And it did. It was about a $15 million estate. That's the one that took almost 7 years to close, by the way, because he made sure everybody fought, and they did.
So a couple of additions to that is you do want to give, if you have rental properties, for example, sometimes you want to give the trustee a period of time to hold on to them and sell them. You know, maybe they have to wait for the lease to mature. A lot of times what happens when you die, I don't know this, but in a lot of families, you know, the kids are like, okay, I can wait for my money. And then I get a call, it's been 5 days, when am I getting my check? But you know, with real estate, it can take time to liquidate, especially, you know, the market's kind of shifting a little bit now. So, you know, you can specify the trustee can hold on to properties for a specific time, you know, or actively market it. The other thing I like to do is if, you know, with the multiple beneficiaries, you know, if let's say the family home's a family jewel or you have Tahoe property or something, I've done rights of first refusal in the trust where a beneficiary can buy a property or a rental property or the home from the trust at its appraised value. And if two or more want it, you know, you draw lotteries to see who gets to go first. But that can sometimes work too if, you know, if somebody wants to be a real estate mogul.
Thank you, Rich. So let's go to our next one. This one will take a little bit of working through. So one or more of my children or grandchildren or my non-married significant other are living with me in my home. My plan is just to let them to continue to live there after I pass. They're aware of my wishes. So let's break that into two. Let's first talk about children, grandchildren, and then we'll talk about the non-married spouse. Looks like, Lou, you wanted to jump in.
Yeah, I mean, actually, this question is right on point with a number of cases I'm dealing with right now. I would say that's the biggest myth, is when people say, well, they know what my wishes are in relation to letting that person live there. And I will just tell you how step parents work. I am a step parent. My mom was married 3 times. My dad was married 5 times. And I will tell you, no matter what, there is always resentments that are going to come out against the step parent when you're gone. And if you say, I want my spouse or so-and-so to live in this house for the rest of their life, the kids are going to throw them out on their rear end within 6 months of you being gone. That's just what's going to happen. They're going to find whatever way to do that, and then the whole relationship that seemed to be in a good place will melt down afterwards. So I would say in your estate planning documents, be very specific about those issues, because if you leave any opening at all, it's going to be a big problem for that person that's left behind.
Yeah, I think I've got a case right now. Well, I'm going to say that because that's a spouse, but for the children, that the house, there's two issues. One, who owns the house after you die? Is there a joint tenant named on it? Is it in a trust, etc.? Because the owner is the one who's ultimately going to decide who lives there and who doesn't, unless you've specified in writing as a condition of ownership who gets to stay there. And it is a huge fight. It's like, oh, I want my grandchild who has nowhere to live. They've taken care of me. They can keep living here. Well, is that living there till they're done with college? Is that living there till they get married, have their grown children go, and then they leave? How long? And the biggest fight every time is who pays for what, right? If you own your own house, even if the debt's paid off, there's bills to be paid, and sometimes substantial. But let's say the taxes and the insurance are okay. You don't have HOAs because you live in the middle of the country. And the furnace goes out. Who pays for that? Is it the person that's living there? Is it the person who owns the house, who probably is different? Right? I mean, that's a tough question. How many of you replaced your HVAC system, right? $12,000. And if I'm only living there for, say, the next 5 years, and that's a 20-year investment, do I pay the $12,000 even though the next person's going to benefit from it? What if the lawn dies?
Or a roof.
Yeah, roof, another big one. So lots of issues there. I think if you want to do that, you really need to specify for how long, who's paying what bills, what happens if the bills aren't paid, those kind of things. What about guests, right? What if you you're very clear and you say, okay, I want my grandson, my granddaughter to live in the house up by UNR until they graduate. Okay, is that the graduate with their doctorate degree 12 years from now? Or is it a bachelor's degree, so you've got that one. What about having their friends in, right? I mean, I will tell you, I loved where I lived when I was in college, with 5 of my closest friends, where we drank more often than we should have, I'm not gonna say the truth, where we moved a pool table into an unsupported dining room because we thought it was the same as a dining table. Turns out those slate things that are under the pool table, they weigh more than a dining table. But it was fine because all the breakage happened in the basement. Nobody could see it. But you've got those issues, and they're big ones because somebody's waiting for that house to get sold and get their money.
Anything else we want to add between children, grandchildren versus a non-married significant other? Or does that kind of cover it all?
Well, I would just say unmarried significant others have 0 rights unless you specifically put them in the document. So that's, creates a lot of problems.
But we've been together 20 years. Doesn't that count?
I will tell you that the kids will probably view that as 20 years of misery for them. Maybe not, maybe you have, but I mean, that's very common where you see that it's just like, oh, finally we can get that person out of our lives.
When I think so there's 2 fights that happen there. So I'm going to use a case I have now. So I have a case where a woman just passed away. She had her significant other who sold his home and moved into her home and spelled out he has the right to live there for a certain period of time. And that's what it says. She has 3 kids, and she died. The 3 daughters show up in my office. Everybody's on the same page. This all makes sense. We're good to go. Okay, great. So I go out and I meet with the guy and I say, hey, I'm so sorry, but here's the way the expenses are going to work. Okay, great. Then one of the daughters decides that the trust paying the water bill, which is sort of what we decided was going to happen, didn't make sense, and she called the water company and turned off the water at the meter because it was too expensive. And now one of the daughters called me up and said, hey, I know the trust owns the property, but I really think we should be able to sell it. and divide up that money, even though he's got the right to live there. I mean, he has the money from his house. He should go buy it. He can afford it. So even when you spell it out, you can get into some nasty fights. You know, as Lou was saying, I mean, you know, this guy allowed the woman to live at home without going into care for at least 5 years. They've been together close to 19. And the kids are still battling about it. Now, my hope is, mom died recently, so maybe this is that emotional, remembering what happened when they were 8 and they're fighting about that. So that's one. But the bigger problem there is there's no specificity over who's paying for what. It just says he has a right to live there. And again, utilities, that one's pretty easy. But what about, the roof, carpet? What about the frickin' lawn that died because the daughter turned the sprinklers off? Who pays for that? Now, my opinion is the daughter does, but we'll see what happens. But the countervailing to that, really, you look at each other and say, hey, you get to live in my home. I love you, and this is a great place for you to be. I do not want you to be on your own. And then actually say, okay, how are we going to divide up who pays for what? Actually, the bigger one, too, who gets to keep the stuff in the house? Right? Your house, this house, the lady moved in.
Yeah, people will often overlook that issue when they're designated somebody to stay there, and that creates some pretty interesting results. Like, people leave the house. Whoever the designated significant other is leaves the house for a day or two, comes back, there's nothing left. Right? It's all gone. All the furniture, everything. Whoa. They said you could live there. They didn't say you got to keep this personal property. And it's one of those things. Like, you go to court, and what do you do?
Yeah. The easiest way, so it all sounds overwhelming and tough. The easiest thing that I've done is you set it up like a lease. I mean, no rent being paid typically, but a lease, a tenant pays utilities. You spell out, do they pay lawn maintenance? Usually the landlord pays for garbage because that's a lien against the home. Water, that's a lien against the home. Taxes, insurance, to make sure that's being paid. It doesn't have to be really hard. You just want to lay it out because I think you said it right. They're just waiting for you to die so they get their money, and now they got to wait till this other fool dies, and now they're mad.
Thank you. Let's jump to the next one because we have 3 left to go. I have to name a relative as my trustee and or executor. I'd like you to take that one, Lou. We all think it has to be someone we know in the family. Is that the case?
Yeah, and so my question to people generally is, a lot of times people will name their eldest son, or maybe they have a son who's a doctor, really smart, or, some very successful career. If it's not in estate planning, if your son's not or daughter's not an estate planning attorney, yeah, you probably shouldn't name them. So the thing with trusts is you're dealing with the cutting edge of, no, I shouldn't say cutting edge, the most difficult aspects of law, finance, and accounting. So a trust tax return or an estate tax return is filed on Form 1041, not 1040. Those are only handled at the highest levels of CPA firms, normally partners or the most senior staff. The trust laws, trust law in general is still, and probate law is still very archaic. There's still a lot of statutory things you have to do, notify creditors, make sure your final debts are paid, make sure the IRS is paid, that's a big one, and the big deal is cutting off IRS being able to do it. If you have a very successful son or daughter that has their own career, you are giving them a 20 to 30 hour a week extra job for the first probably 2 to 3 months. And I mean, people get pretty resentful. Like, I had no idea it was going to be this much work. Plus, if you have multiple children, like I said earlier, all those conflicts are going to come out. And then it's going to be, well, why did mom and dad favor you over the rest of us? What rights do you have to that? It creates just a huge mess. And just the level of difficulty. It's often, I think, naming a corporate trustee, somebody detached from the family, is a much better idea. And keep in mind too, that whoever you do name as trustee becomes the de facto owner of all your assets. So they can do whatever they want with it. And I have at least once a month people coming into my office, my parents named my brother as trustee, he has a gambling problem, he won't give us the statements on the accounts, and we don't know where the money is. I'm going to tell you that money is gone. You are never getting it back. There will be very little consequence from what I've seen to the person that did that. Just honestly, nobody's interested in prosecuting that type of crime. It's just not going to happen. It's just gone, forever gone. You can never undo that decision. And so it's relatively inexpensive to name a corporate trustee. And it's like buying an insurance policy, really, to make sure that stuff doesn't happen.
Thank you, Lou. Did you have something? I've got like two more to get through, and we've got about 3 minutes.
I'll be really fast.
Okay.
The benefit of a trust is it's quick and it's private. Disadvantage of a trust, quick and private. If you have the wrong person in charge, as Lou just said, things go off the rails, they're not going to get back on the rails. It happens so fast. And secondarily, we've got a little sheet out there, a handout. There's questions about who should be my trustee. So pick one up because it'll help you walk through that process.
And we have the same as well, reasons to name a non-family trustee.
So you have information out there too?
Yeah,
Lou?
and information at our booth.
So make sure you go by Lou and Rich's table on the far end as you go out. So the next one, I can have my estate planning documents created or updated whenever I want.
So quickly, yes, provided you can think clearly. That's the big one. The other question about that is it becomes very difficult if you move into assisted living, to update powers of attorney in Nevada, because we hit earlier that there were some protections put in place because of abuses. But those protections can make updating estate planning documents a little bit more challenging. The other thing about that you want to be careful of is when you're updating it, who's in the room, so to speak, right? If you're updating it and you say, okay, I've got 3 children and I know, Johnny's been in charge of my trust forever, but Mary's my favorite person now and, everybody loves Mary. Well, really? Or is that only because Mary's been the one whose house you've been living in and who's been using your money to pay her bills? So, when you do update a plan, if it's later in life, you're going to have, hopefully, and it's that kind of a situation, the lawyer's probably going to ask you some rude questions. And that's not rude, it's just to make sure that people honor your wishes.
Yeah, and I would just add to that, you may not necessarily be thinking clearly later on when you do make these changes, and you're not going to know you're not thinking clearly. So I think trying to think things out as far ahead as possible, but it's so often that we see changes to estate planning documents within literally a week of somebody passing away with a terminal illness. I can almost guarantee that person's not thinking clearly at that moment in time.
Yeah, I mean that even if you were thinking clearly, if you did a significant change that affected who gets what, and it's a week before you die or 2 weeks before you die, which happens a lot, you're probably on pain meds, you're probably not thinking clearly, or at least that's what the people that aren't getting as much as they think they should get. Now, whether or not they win that fight, it's a big one. But if you're thinking, oh my gosh, I need to change my estate plan, it's much better to do it earlier than later.
So you're saying because it might be challenged, the children are going to challenge those
Correct.
changes based on the circumstances.
And one of the most expensive areas of law that there is trust and estate litigation. Those bills are
I prefer to think of it
insane.
as lucrative, but okay.
Thank you. So our last one, before we move to the audience questions. I'm not married and don't have kids, so therefore I don't need an estate plan.
I mean, if you really don't care what happens to your stuff and you just are like, yeah, somebody will figure it out, then yeah, I guess that's fine. But if you don't, you know, where's your property going to go? If there's no heirs, basically it's going to end up with the state. You don't have a charity, you don't have a foundation that you want to support, you can't think of anything to do with your stuff. I mean, I guess if you're not a very nice person, you could just say, yeah, figure it out. But everybody should have an estate plan to deal with, even if you don't have children. Where do you want it to go? What's the cause you want to support after you're gone? I do think it's important even without children.
I think the toughest one, I get that all the time. Somebody comes in and says, this can be very easy. I have no kids. I just want my stuff to, whatever. The hardest part when I'm working with somebody like that is what happens if your brain stops working? What happens at the end of your life, right? I'm married, I have kids. The state will eventually let them start to make decisions for me at some point. But, if I don't have those folks around, what do I want to have happen? How many of you want to be on a machine for 20 years? Well, if you don't have a decision maker and you have no family, they have to keep you on that machine for 20 years. Otherwise, it's called murder. I finish that thought. Lou's company, I know they've done that work. You can find someone, an entity, a person, to help you at that stage of your life. Even if all they're doing is saying, hey doc, this says pull that tube out, right? You want somebody to be able to do that for you. And without something in writing, without a plan put together, what you're going to hear at the end of your life is beep, beep, beep for 20 years.
Yeah, for me, it's the last thing that my kids, it's the last chore I'm assigning them for their lives. It's like, hey, I've talked to them about it. Like, hey, here's my wishes. You're going to have to figure it out. This is, but here's a roadmap. But this is what you have to do for me. The last thing you have to do for me. Last chore.
I'm so glad you've had that conversation, though, because that gives them an opportunity to ask you, well, what do you mean by that, Dad? What does that specifically mean?
Yeah, and I will also say that from my experience, like, I honestly advise people to be as transparent with their children as they possibly can, unless your children already hate each other, in which case, maybe that's not the best course of action, but trying to be open about what you want done after you're gone or at the end of life, I think makes things go so much smoother. Even though it's I understand it's a difficult conversation.
So let's move to your questions. So hopefully you've written down some great questions for Lou and for Rich. So if you have a question, please raise your hand and Grace or Trish will get over to you. Lots of hands, great. So we have quite a few questions, so if we can kind of keep our responses short, guys, so we can get through as many as possible. If you could please just keep it to a question, not a comment or anything at the moment, just one specific question, and then if we have time for comments and so forth, we will later. You start.
Okay, I wrote it down. How expensive is it to have an existing trust reviewed to make sure it's still current, and how often should we do that?
That's really a question for Rich. So, we look at trust, but we don't provide legal advice. But we're happy to share things we've seen other people do. As a general rule of thumb, we don't charge for that if you're going to name us as successor trustee. But Rich is really the one that would review.
So on that though, I could come to you if I wanted you to be my corporate trustee and take care of everything. You would look it over because I'm still alive and go, there's some holes here, Brett. You might need to go see Rich and revive some stuff.
Correct.
Yeah. Okay.
Yes.
Just wanted to understand that.
So generally, we don't charge for a review of an existing plan. Rule of thumb, anytime there's a major life change, you want to get it reviewed. So it's particularly in your decision makers or who gets what. Every 3 years is what I kind of tell people you want to think about it. Because, your kids change, your decision makers change, your wishes change.
So if you're not my attorney, you are, but if you're not, I could come to you and you review mine and make suggestions or say it's great, and then I can decide from there what to do?
Yeah.
Okay, thank you. On this side.
Question for Lou. What's the cost for your estate management?
So for us to handle it, if it's just a straight settlement, which is basically we wind up your affairs, which includes oftentimes final tax returns, disposition of personal property, etc. It's about 2% of the net value of the estate. So, less liabilities, assets, less liabilities, basically about 2%. If it's an ongoing administration, which is that we're going to say you want to take care of your children or your grandchildren forever, it's generally, we charge, 1.5% of the first $1 million, and then it declines about every $2 million by about 0.25%.
What I want to point out is what Lou said. Correct me if I'm wrong. 2% of the net value.
Correct.
So
I picked up on that compared to probate.
Yeah, that's compared to probate, and when you say, "Oh my God, it's 2%," that's awful. It's really not. If you look at other companies, they charge 1.5% of the gross estate. A lot of them do. So, Lou and I will have a talk about fees in a minute.
Yeah, I mean, it's generally it's not. It's like an insurance premium, quite frankly.
Thank you. Over here.
My question's along the same line as this lady's. I had my trust updated a few years ago by the company that did the trust. Well, it cost me $3,000 to have that done, and they only changed about 3 or 4 pages. So I'm going, how do I find somebody to update my trust that doesn't charge me an arm and a leg?
Okay, so I am undercharging. I made a note to myself about that.
I guess I shouldn't have told you.
I have 2 comments on that. The only reason to do estate planning is to stop worrying about the things that we worry about anyway. And if it's $200 or $18,000, what's peace of mind worth, really, at a certain level? So I don't mean to be flippant about the fee you had to pay. But the question people ask me all the time, and I tell them, ask me the question, what's this going to be? And is it ongoing? Is it one time? Like that. And a lot of it's kind of interviewing. I mean, there's firms in town whose fees are extraordinary, but then if you go and look at them, right, they were involved in the Fox News litigation, right? That happened here. That firm's probably going to be a lot more expensive than a firm that, just is local. But the idea is, interview people and just ask them.
And I would just point out, it depends on how much what the substance of your change is. Just from what I've seen, generally, just small changes are just, an hourly rate, whereas sometimes you need to completely restate the trust, and that's basically doing a brand new one.
Larry.
Okay, I have a question about the children. If you have 2 or more children, should you or should you not put them both equally in charge of your estate?
Good question.
I mean, it generally depends. Like I said, even with the rental properties, I generally think that is a recipe for disaster. You're forcing them to make really complicated financial decisions together. You know, one may be an artist, the other one may be a CPA. Like, there's no way they're going to agree on anything, except maybe what the paint costs. But, you know, it's just really, I have not seen that work out very well, really, except in rare instances. But generally, the siblings are going to have an issue.
And I think there's nothing legally prohibitive about that. Where the difficulty comes in very frequently is all major decisions take both of them. So you want to sell the home, both signatures. Want to open a bank account, both signatures. It can become very unwieldy doing that. And as Lou said, they both have to agree on everything. And that's usually why people do co-trustees, right? I want them both involved. I think this is a great idea. But again, in the dramatic event, an artist and a CPA, you know, what they're going to agree on is human beings need to breathe and need to eat, but they're not going to agree on what they need to eat or what they need to breathe.
So if your children are like amicable, good relationship, would it be worth maybe having a conversation with them and asking, you know, this is how it is, you're both going to have to sign everything, you're both going to have to go to the bank, or would one of you rather lead that?
Yeah, so I mentioned in the workshop, we'll talk about that. That's one of the questions we'll talk about is, yeah, if you're looking at your kids, it's like, I want both of them because I don't want to hurt either one of their feelings, etc. It really is worth sitting down and saying, hey guys, one day soon, or hopefully not soon, I may not be breathing. And, you know, what I'm thinking is I'm going to put, you know, Barbara in charge, and this is why, but Barbara, what do you think? You know, Mark, what do you think? And find out. And Barbara may say, you know what, I get it, Dad, it's awesome, but Mark really is going to be better for that.
Thank you.
How is it decided, say you just have a will and not a trust, how is it decided if it goes to probate or not?
It goes 100%. There is no decision. It has to go to the probate court if you have a will. It has to be lodged with the probate court. So you have to go through the probate process if you only have a will. It's a 100% ticket, 100% of the time it's a ticket to probate court.
What if I don't have a property, minimal assets, is that still the case?
Yeah,
is there some level before it has to go to probate?
One comment on Lou's is it's not a will until the judge says it is. So, and then, yeah, the question, there's tiers of probate in Nevada. So if you've got a modest estate, we may be able to do it through something called a set-aside. A little bit bigger, we can do a summary administration, and it may be a full administration if it's more than $300,000. The reality is, though, that the fees, as I said, 3 to 4%, and the timeline's the same regardless of the size. But beneficiary designations could affect. You know, I have a will, and my main asset is an IRA, and my son's the beneficiary of that. Yeah, your son's going to get the IRA, and the will may not handle anything because everything just went by beneficiary designation.
It just, you still have to file with the court. Yes. Anytime you have a will, you have to lodge it. So even if it's with a set-aside petition, still have to get that paperwork filled out, still has to be sent in, even if it's a summary administration. At that point, you're going to need legal help. So yeah, a will is always lodged with the court. Yeah.
Thank you both. Where's my mic runner? Thank you, Tricia.
I don't have children or grandchildren. I was going to divide equally between my surviving siblings. So my question is, all of the suggestions that you have made so far, would those be applicable when you're dividing between siblings and not children or grandchildren?
Yeah, I think so. The relationships are a little bit different. Your siblings are, I would guess, pretty similar in age. They probably don't want the burden of dealing with that at that point in their life. But yeah, I think it's all pretty similar, whether it's siblings or children.
Yeah, I think similar issues, and as Lou pointed out, the difference probably between your children and your children in general and siblings is children have things that happen when they're 8 years old that really will come up. and your siblings probably aren't going to have that kind of a fight.
Unless you weren't nice to your sibling.
Yeah, unless you weren't nice, in which case, you know. Yeah.
Hi, I have actually two questions. I don't understand where that trust goes. In other words, when I have a trust done, is it registered somewhere with the state? Can my other part of the question is, so my family needs to know, because I have it in a book, where it is, and can they go without an attorney and get it straightened out, or do they have to pay that extra 2% after already paying for a trust to get it all straightened out through the courts and everything?
So if there's some statutory timelines there that Rich could probably speak a little bit better to, but, notification of trustee and which gives you a period of time to challenge or change a trust potentially. But I mean, if you need to you can always petition the court if needed. You can always, they can always do what's known as a notice of proposed action, which as long as everybody who's a party to the trust agrees, they can make those changes after you're gone. But I would say, the situation is, it just kind of depends on what the issues are. But as far as the trust document itself, I do recommend that you have an electronic copy. I do recommend that you have a copy with whoever drafted it, the legal counsel. And you know what? Give a copy to the beneficiaries. Unless there's going to be a surprise in there for one of them, I would say share it. That way, nobody shows up and says, oh, there's a different group of estate planning documents, which I did have happen before.
I think the first part of Jan's question was, though, is this registered anywhere, the trust? And that is no.
Yeah. So, the question is, the trust isn't registered. It's just between you and you when you're alive. One of the caveats I think I have to Lou's comment to giving copies to folks is I'm not a fan of that generally. If you're getting towards the end of life, you want to reach out to your trustee and say, here's what you're going to do. And the reason is, if you've got some lifetime left, you may change it. And if you change it to take out the trustee, for example, that you named because they're a bonehead, or you disinherited one of the people you thought you were going to inherit, you don't have to go back to them and say, hey, yeah, you know that fight we had? It's got a cost. You're not getting anything. And then to your second question, what does it take? I think a lot of you heard the story, and I'll be quick because I know we're running out of time, but my favorite trust story is I had a woman show up in my office. Her mom was a client of mine for 15 years. She sits down at the table and she's wearing sweats and her hair is all messed up and she's crying and she's just a hot mess. And I talked to her for maybe an hour, 15 minutes maybe, and she leaves. I never hear from her again. Happens. 9 months later, 8 months later, I'm at the brasserie downtown with my wife, and this beautiful woman comes up to me, gives me a great big hug, kisses me on the cheek, and starts singing my praises. And I'm thinking, the universe finally recognizes how great I am. I'm looking for the bells and the angels. This is going to be great. I have no idea who she is. I'm hoping for my wife to interrupt and say, hi, I'm his wife or something. And I finally had to say, my wife's hitting me. I'm like, okay, I'm sorry. I don't know who you are. It was my client's daughter. She thought I was the Wizard of Oz. She went out, sold the house, closed out the CDs, got everything handled without me, without any real help, and thought she really did think I was following her around, making it easy. But when the family gets along and the assets are relatively straightforward, it can work that way. The risk you have, coming way back to what I said, and Lou's talked about this a bunch, is if it's the wrong person in charge, things can get off the rails. Let's say they can sell the house without anybody knowing because your trustee owns the property. They can do anything. And they can tell the family, that $1 million house, the market was down, I sold it for $400,000. Oh, don't pay any attention to my new boat and the car and the fact I was in Europe for 9 months. So if the right person's in charge, sometimes they can really get it done on their own. That's my point.
So just a show of hands, who still has questions? Yeah, we still have quite a few questions. Let's jump to those if we can.
Yeah, I just wanted to say, just a person that you trust, leave a copy with them as well, besides leaving it to be found.
Perfect.
How do you go about choosing a corporate trustee? What criteria should you use?
You know, I would just say interview them. Phone call, you know, what is the process? What does this look like? What do you charge? You know, what experience do you have? You know, I think for Alliance, one of the things that I think we do really well is I have built a very specific estate settlement team. I do think this is an area of growth. It's was the baby boom generation is, you know, now going to become, I guess, the baby bust generation. But it's you know, there's a lot of this coming, and so we've created a very specific team that can pretty much handle any situation. You know, we have 4 CPAs on staff, we have 2 JDs, CTFA, a couple CFAs. So basically we designed the firm so that there would never be a situation that we could not handle. And we've handled, you know, I've had to access a safety deposit box and a numbered bank account in Switzerland. And I will tell you, that's really hard to get Swiss banks to, you know, comply. You know, we've handled, you know, just incredibly complex commercial real estate deals or incredibly complex, you know, individuals who have children all over the place. So, you know, I would just say the stories, I think, more than anything else, the stories that a company can tell you, I think, tell you how experienced they are.
Great answer.
I think if I could real quickly, one of the things I would do is take your plan and say, this is what I want to have happen, and here's my assets. What happens when I stop breathing? And have them tell you. And make sure it aligns with what you want to have happen. Because a lot of times trust companies, not Alliance, but I've worked with some of them, and they say, I have rental properties and I want them kept in trust for 5 years when my kids mature. And you go to the trust company they've named, and the trust company says, we don't do that. We would sell them right away. Good to know before you stop breathing.
Yeah, some trustees will not handle certain assets. So just be aware of that. Rental properties is one that I think people are afraid of. I don't think any trust company will handle cannabis assets. So just, that's a real problem for any trust company. So just be aware of that.
Thank you. What was that?
I have a question about if you have a trustee who is a friend, how much do they get paid as far as how much can they expect to get paid to cover handling your whole trust? And the other question was, if I've specified where my houses are going to go, can a trustee decide that they're going to sell them instead of getting them to that person that is going to inherit the houses?
I would say that both those things would be handled inside the trust document. If you say house goes to X and the trustee doesn't do it, they have some real liability. So, you know, that's a contract. Basically, your trust is a contract between your beneficiaries and your trustee. And so the trustee has to follow the terms of that agreement. As far as charging fees, if you don't address it in the trust document, you know, I mean, they could probably follow what other trust companies do and be fine, but they probably want to get agreement from the beneficiaries before they do that to head off potential problems.
Yeah, I think the only exception to the house thing is if there's no liquid assets, the trustee's primary job is to make sure the bills get paid. And if you've got 5 properties and $500 in cash and you owe, you know, $2,000, they're gonna have, well, they'll have to sell the house to pay that or sell a property. And trustee fees, I think as Lou said, you know, what I do is I pull up 3 trust companies' fee schedules, lay it out and say this is what you're going to expect to get paid. almost always they say, oh, I'm not going to get paid. And then, 3 months later, like, oh, no, I'm going to get paid.
Yeah, what was I thinking? This was way more work than I thought.
So I'm hearing you say, though, that should be specified in the trust documents.
Yeah, some
or the
reasonable.
trustee.
I usually specify reasonable compensation, because the risk is you say, $100 an hour, which sounds good today. Inflation goes to 10% a year for a few years, and $100 will buy you a cup of coffee.
Yeah, what we normally see is just reasonable compensation. That's broad enough to cover anything.
I know we had a couple more questions, but we've hit 11:30, so just to respect your time, I'm going to wrap it up now. But if you do have additional questions, please come up. Lou and Rich are going to hang around, and they'll answer your questions one-on-one. And if you could just complete the yellow evaluation form, if you would like to attend one of the upcoming workshops or the seminar, please note that down, and please put your name tag or your details so we can follow up. Would be appreciated. And if we can have a round of applause for you being here and for our panelists. Thank you, guys. We look forward to hopefully seeing you all next month.